everyone. Welcome to today's webinar, Keeping It Legal Online, brought to you by Polaris Law Group in partnership with the North Metro SBDC. Thank you for taking the time to join us today, and I'd like to go over just a few logistics before I introduce our speaker and we get started. So we'll be taking questions throughout this webinar. We have enabled our question feature on the right-hand side of your screen in the GoToWebinar panel. So as you have questions come up throughout Samantha's presentation, please type them in that panel. And actually right now, to get comfortable with that feature, you can type in your name and business name so we can see who all is joining us today. So we appreciate your active participation with that. And you can also see Samantha's slide deck under the handouts tab in that same right-hand panel over there. And she'll be going through that during the presentation today. And then we're also recording this webinar and we'll be posting it online later today. We'll send out an email with the video link when it's available. So for some introductions, I'm Hannah Curtis. I'm a coordinator with the North Metro SBDC, and I have with me today John Hovey, our special projects consultant as well. We're joined by Samantha Peaslee with Polaris Law Group. Samantha has been a North Metro SBDC legal consultant since 2015 and is an international business and intellectual property law attorney, focusing her services for small to medium-sized businesses and nonprofits. So Samantha, thank you so much for being here today. We really are interested to hear what you have to tell us about this important topic of protecting our business's online presence.
Thank you so much, Hannah. I'm glad to be here today. Anyone who needs the slides, like Hannah said, they're on the side. Mostly we just have them here for me to keep on track because we have a lot of fun things to talk about. I probably won't get to everything that we could talk about with keeping it legal online today. And I will say just from the outset, we are more focused here on how businesses outreach with their clients and customers online. How businesses interact with their employees and contractors online could be an entire another presentation. If you have questions on that, we're always happy to take that later. As Hannah said, I'm Samantha Peaslee with Polaris Law Group. We serve small, medium-sized businesses and are a small business. We're happy to be here with you guys today. Always have to give this legal disclaimer here. Little less concerned about it with the current format. But this presentation and materials provided with it are intended for educational and informational purposes only. I can't give legal advice over the course of the presentation. This is all general. For those of you who are asking questions as we go along today, I would ask that as a courtesy, you keep your questions general rather than specific to certain instances within your business. Obviously, if you're asking whether something can be done and you think that that would apply to many kinds of businesses, that's fantastic. If you have more personal questions about whether you can do a very specific thing, my answer to that today is probably going to be that we should set up a consultation through the SBDC. Not trying to be rude, just trying to make this as applicable to as many people as we possibly can. Still ask your questions, absolutely. Just if I give you that answer, that is the reason why. Also a tax disclaimer, because there will be one or two times that I mention some tax things. I am not an accountant or a tax attorney, and nothing in this presentation is meant to give you tax or investing advice or other financial advice. Always double check with your accountant or bookkeeper before that. And now with that out of the way, the actual presentation. So this is a view that some of us have gotten used to over the last several months. With COVID-19, all of a sudden working from home became the norm. All of a sudden operating online became the norm. Many of us were operating online in different ways before this, but with everything shifting, with the way that business has been changing as a result of the pandemic, people have jumped online a little bit more quickly with some things. And some of the people who weren't traditionally online have moved business or aspects of their business online. And there are several things to consider before doing that, even for the smallest of businesses. So if your business has recently moved online, this is great for you to make sure you're doing things correctly. If you've been online or if your business is naturally online, this is still good information for you to know, probably even better information for you to know because you'll be using it much longer than the current situation. So we're going to be talking about 3 categories today that are most important in keeping it legal. First one is personally identifiable information, kind of breaking that down, demystifying that one a little bit. The second one is intellectual property. This is not going to be a deep dive into intellectual property, just a couple of the basics that you need to know if you're doing online business. And third is going to be sales and solicitations. At the end of each of these sections, we'll take some questions for that section. Depending on timing, we might only take a few questions for that section, the ones that are most widely applicable, and then come back to other ones later. I will, of course, give contact information at the end if we didn't get to your questions today, or again, get to consultations. If we have extra time, then we'll get to how to deal with bad reviews. If we don't have the extra time, you have access to these slides. You can look at that on your own, but it's always a fun little way. It's not strictly keeping it legal, but it is often a question that people have, and so we've turned it into some bonus material for you. With that, jumping into some personally identifiable information. This has become a big buzzword in recent years, and quite frankly, we all have it and we all collect it. How much we collect and what we do with it depends on our businesses, as well as where we're doing business. So the first thing that we're going to kind of jump into is what personally identifiable information is. However, that's not an easy answer. Personally identifiable information is different from legal jurisdiction to legal jurisdiction. So it's defined differently in Colorado than it is in Texas, than it is in Utah, than it is in New York, than it is in Italy, than it is in Japan. That doesn't make this easy for us. The problem with this is that unlike brick and mortar, when you're online, if you want to limit your presence, you have to affirmatively limit your presence. What that means is that you have to say, we don't ship or sell outside of the continental 48. We don't ship or sell outside of Colorado. You have to have bars in there for people to view that. Otherwise, you're open to the entire world. So with that, what is personally identifiable information and where? So first of all, in Colorado, I'm assuming that most of the people in here are in Colorado and are coming into Colorado. It's always really awful when I flip to a slide and the first thing I see is a typo, but that's okay. In Colorado, the Colorado Privacy Act, the following things are identified as personally identifiable information: social security numbers, PIN numbers, passwords. You see a theme in here: driver's license, biometric data, financial transaction data. It's those high-level things that would allow a hacker to receive financial or medical information from a person or to log on to their sensitive information. If you are just doing business in Colorado, this is what it means if you're collecting personally identifiable information. But remember, when I said just doing business in Colorado, that doesn't mean that your physical address is in here. That means the people who can interact with your site. So what we often have to look at for websites is not Colorado, it's California, which is the highest standard of what privacy is in the United States. So if you have people from California who can look at your services, who can subscribe to your services, who can get on your mailing list, who can purchase things from your shop, this is the standard. Who can attend your webinar. If we have any Californians today attending our webinar, this applies to you. And you'll notice this is a little different. In California, personally identifiable information is any details collected on the internet about an individual consumer. This is names, usernames, physical address, hair color, anything that can be combined together to get more information about a person is considered personally identifiable information. Now we know things like if you just have a first name, a last initial, and no other information, that's not personally identifiable information. If you just have a first name and a username, that's not likely to be personally identifiable information, but it's a closer call. you have a username plus a password, ding, 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 personally identifiable information. Obviously, any birth dates. If you have first name, last name, birth year, that's going to be considered personally identifiable information under California. So you'll, of course, know that all of this is especially important if you're collecting information. If people are signing up for the webinar today, what did you probably have to enter in? Your first name and your email address. That's personally identifiable information. So under California, we have that much higher standard than Colorado. Then if we go global, and this is particularly important in light of recent law that has come down out of the EU, the GDPR is the highest global standard. So the GDPR actually is not quite as harsh as California's in the what personally identifiable information is, but it comes down to the same thing. And the GDPR is important because its enforcement provisions are much harsher. So if you're going global, you're looking at any information relating to an identifiable person. Okay, so we're back again to first name, last name versus first name and address. What is that? Any location data, that would be address, that would be zip code. Identification numbers, always. Online identifiers, that would be usernames, emails, passwords. And then they have their catch-all, one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So that's what personally identifiable information is. For a lot of practical reasons, we usually have people assume that California applies, unless they have affirmatively said that it doesn't. Because most of us with businesses here in Colorado, we don't prevent people from California from being able to view our website, enter information into our contact us page, or other things like that. So knowing that, we have to look at some key questions on how to handle that personally identifiable information. Because ultimately, why are we worried about personally identifiable information? Because if you misuse it or lose it, you could be responsible for any harm to all of those people. We've all gotten those notices from someone like Target or Equifax when they get a breach. Sometimes it's just a, hey, we're notifying you, but we don't think it's a problem. Sometimes it's a, you're getting a check for $100 in the mail. Sometimes it's a, you may be a party in a class action lawsuit. And we don't want that for our small businesses. So once we know we're collecting personally identifiable information, we ask these key questions to help you better protect yourself. Why do you collect it? Is it so that people can come watch your webinar? Because that's important. Is it so that you can ship the item that they have purchased back to them? Is it so that you can contact them for the appointment that they made for your services online? Those are all. Is it for payment? That's a common one. The second question is, how do you keep it? And one of the questions with that is, do you personally keep it? Or does someone like Squarespace or PayPal keep it for you? Does it live in your email? Does it live on the cloud? Does it live in the server? Does it live in an Excel spreadsheet that you keep on your unsecured computer? These are important questions. Then what do you do with it after? Does it stay in a box and you never think about it again? Do you use it specifically for that shipping or for that webinar and then delete it? Do you use it for that shipping and that webinar and then add their name to a mailing list so that they can get promotions and coupons in the future? Do you sell it to a third-party advertiser so that they can get more of that information? These answers to these questions will determine how we then need to protect it and what your risk level is for personally identifiable information. Forbidden uses for personally identifiable information, you'll notice a key word in all of these. That is unauthorized. Unauthorized. Now, it used to be that if you have given your personally identifiable information to someone, you have just authorized them to use it for everything unless there were limitations put on it. Now it's the other way around. The general rule is that people give you your personally identifiable information for and only for what they have specifically agreed to give it to you for. And that if you spread it out or use it in any way other than that, it's unauthorized. So unauthorized access. That means if you're letting your contractors see people's personally identifiable information and you don't have an appropriate protection clause in your contracts with your contractors, that may be unauthorized. If you haven't notified the people giving you that information that you utilize contractors who will be giving that, then that may be unauthorized. We don't count the payment methods in this when you say, like, you're going to be taken to a third-party website to pay for this. That's an assumed at that point, but it is best to tell them. Unauthorized use. If they signed up for a webinar and you're putting them on a mailing list, that's an unauthorized use. Unauthorized modification. This one isn't going to be with the average person. This is more of that financial and medical information. If you are taking that information, logging into something of theirs and changing information, obviously not okay. When does that apply to us? If a hacker gets into your database, takes that information, then uses it for unauthorized modification, you may be responsible, which is important. Unauthorized disclosure, that's the sending it to the hackers. That's the sending it to your third party who will be advertising for them. And unauthorized destruction, that goes back again to the financial and medical information. So these are the things that we're worried about with personally identifiable information. So what do we do? What are we required to do as small businesses to protect against that? And this is where it becomes all right, learning what you're responsible for to learning how to deal with this. So we're required to give only secured access to that information. Does that mean that every time somebody accesses that information, it has to be behind a double authentication VPN? No, it means that you are only giving it to people who know to keep it in a particular place or who have contractual obligations for it, or who have some other permission to access it. Oftentimes, if you're using a third-party provider for a website, you will have to make sure that they have access approval for that because they will have it, and so you just have to disclose that. And we'll talk about that a little bit on the next portion. Secured storage. Where are you storing it? Are you just storing it on the cloud? Are you just storing it in your iCloud account? Is that iCloud account secured? You need to know that. Does it run through, do you have some sort of virus protection that scans the information? That's also important to know. If it is not being stored on your computer, if it is being stored offline, how is that secured? Is it being stored on the server? And if so, how is that being checked? So that's secured storage. What we're required to do is to have a level of security that is appropriate with the type of information that we are keeping. So for most of us, if we are just keeping names and email addresses, we're going to have a lesser security requirement, a lesser secured storage requirement than we are if we're keeping medical information or social security numbers. Then we'll have a higher security requirement. Unless you're keeping information from people in the EU, in which case you will always have a higher security requirement. Our requirements are also to make sure that people have opt-in and opt-out options. That means that they can't stay on your mailing list forever. It has to be easy for them to say, I don't want this anymore. It has to be easy for them to reach out to you and say, I need you to delete all my information. Okay, that's what those opt-in, opt-out requirements are. That's also right to be forgotten, is that ability to reach out to you and say, I need you to delete all my information. And we are required to notify our users what those forbidden uses are, how we are not going to use them, to basically put some requirements on ourselves. So that's what we are required to do. How do we do this? This is the practical part. honestly, and what we've always said with this are disclosures. Just tell them. That is the easiest way. When you collect personally identifiable information, answer those questions for the people that you're collecting them from. So going back, answer why you collect it, how you keep it, what you do with it. That is the best disclosures that you can do, is answering these 3 questions in those disclosures. That includes who has access to it, why you can use it, why, whether it will be modified, how it is stored, what security you use. You'll see those disclosures a lot on website pages. Under the California law, you must have a place on your website that has a privacy policy. It must include the word privacy in it, and it must be accessible from every page on your website clearly. I also think it's a really good idea to always have a link to those disclosures at the point where the person is giving you that information, just to keep things safe for everybody. Agreements are going to be even stronger than disclosures. Make sure that when they're giving you information, they affirmatively agree to give you that information, and that they affirmatively agree to the uses and purposes that you have done. This can be done, it's not my favorite way, but it can be done in the checkbox method. If you have checked the box and you have a link to those privacy policies, if you don't have the link to those privacy policies in that checkbox, probably not going to be enforceable. It can be the scroll and click. It can be an affirmative agreement if you have one-on-one agreements with your clients. It can be before they put that thing in that shopping cart. Either way, as long as you have that affirmative agreement. Getting yourself some good security. Sometimes that's a third party. Sometimes it's just a knowing where you save things. Sometimes it's making sure that your own cloud storage is password protected. It's also a making sure that you're aware when you have potential security breaches. And that's where most people fall off a bit, is if you're all of a sudden getting suspicious emails into your inbox and you don't go change your passwords for everything else, you may now have something on your computer that is tracking every piece of information that you're putting in there. I'm not saying we all have to be security experts, but as small business owners, it is our responsibility to be aware of what those base level threat issues are, to have some sort of antivirus on our computer, to conduct periodic scans, to change our passwords at least once a year, and because we will have notification requirements of every person whose personally identifiable information we have if there is a security issue at our business. So it's important to keep up with that security. To have limitations and enforce them, that's if you have employees or contractors who you don't want to see things, make sure that they know that they're not permitted to see those things. If you are not permitted to give those to a third party, make sure you're not agreeing to give them away in referral agreements. And investigations, which goes back to the security point that I discussed a second ago. So before we jump into intellectual property, before we go too far from that, that's your basic overview of PII, what it is, why we collect it, what our responsibilities are for it, and what we can do to help protect ourselves with that online. Hannah, do we have any questions about that?
It looks like all the questions that came in about that you have answered. So good job on having a very clear presentation there. But for folks, as you have other questions, feel free to keep popping them in that questions bar, and we'll have a chance for this again after our next section.
Perfect. And like I said, I will give my contact information at the end. If you have specific questions to your business, please set up a consultation. They're free with the SBDC, and we can always talk one-on-one about the specific needs for your business. So that's personally identifiable information. Now the slightly more fun stuff, intellectual property. I'm biased. As well as the intellectual property, we're often going to be starting talking about what you're creating. While there is that infringement section, I always feel with personally identifiable information, like I'm telling you a lot of things not to do. And with intellectual property, I'm more helping you protect what you have put a lot of hard work into. So before we go into what your intellectual property is, I'm going to give a brief overview of the types of intellectual property, and I say brief because I really mean just we're going to talk through that there are 4 types and kind of what they are, so that we're understanding the same language as we're going through here. So over at the far left, we have patents. I always put patent at the left because it is, a lot of people think of it as kind of the epitome of intellectual property. It is definitely the hardest to get. It is one of the most valuable. If you have it, it is highly respected. It's also the most expensive. Rarely, if you're doing online work, will you be too worried about patent in these situations. If you are actively creating software or an app, or you're doing some kind of invention or process online, you might be worried about patent. It might not fall into patent, it might fall into the other ones, but usually if we're talking about online intellectual property, we're not going to be talking about patent too much. What we are going to be talking about a lot is copyright. Copyright is any original work of authorship, okay? It doesn't have to be creative, but it often is. Copyright is websites, just flat out. As long as there is original content on that website, your website is probably copyrighted. You'll notice there's a copyright on this presentation down in the lower left-hand corner. Copyright are your photos, they're your videos. I know we have at least one drone business in here. Almost everything that you do is going to be copyrighted. We do a lot of things with photographers. Any of those blogs, those are going to be copyrighted. Any of these videos, if you're posting YouTube videos, those are going to be copyrighted. And I say copyrighted, you don't have to be registered to be a copyright. If you are registered as a copyright, you get some additional protections. However, you can hold a copyright without registering it. The difference, as you'll see, you notice that in my presentation on that lower left, I have the word copyright written out, and then with the person who's copyrighted it, and then the year that it was created. If this was registered, I would have the C with the little circle underneath it, or with the circle around it. Don't use the C with the circle around it otherwise. That involves a fine with the Copyright Office. This says that this is, I think that this is an original work of authorship, and that if somebody tries to take it, I will claim it as an original work of authorship, but nobody has verified that for me, is what that indicates. Most of what we talk about with keeping it legal online will deal with copyright. Note that designs of websites are very rarely copyrighted. That's usually standard materials, or if it is copyrighted, it's usually owned by whoever the Wix or the Squarespace or the GoDaddy is. Trademark, those are brand identifiers. Polaris Law Group, trademark, brand that identifies my firm. The Coca-Cola logo, trademark. This guy, if you guys can see it, the Bronco, it's a trademark. It is a name or logo or phrasing that identifies a brand to consumers. A URL is very rarely a trademark in and of itself. There are a couple of exceptions. Booking.com case just recently came out and was upheld to be one of the exceptions, Amazon.com. But for the most part, your URL is going to be different from your trademark or your trade name. Same idea with trademark. You can write it out, spell it out, trademark Polaris Law Group 2020. If you use the R with the circle, that's an indication that you have had it federally registered, and there will be a fine if you have used that without it being accurate. And then finally, trade secrets. These are rarely going to be involved in your website, but will be involved with that PII that we collected earlier, because trade secrets have to be secret. If they're not secret, if they're on your website, they're not a trade secret. However, this is often business information, client list and information, your processes and procedures that are not patentable, they're not new enough, but they are unique to your business would be an advantage if you have them. So what we're usually talking about with your website, hopefully everybody picked up on this as we were going through. Sometimes when I do the yes, you do have intellectual property class, which is a full thing on intellectual property, go through it, and as we're talking, I'll say, all right, as we talked about those copyrights, think of 3 things that you have that are copyrighted. Think of something that you have that is trademarked. Usually everybody has a couple of each of those. So hopefully as we've talked through that, you are already thinking of what is on your website that is like that. So first, we're worried about protecting your own copyrights and trademarks, potentially the other things that are on your website, that PII that you've brought in. There are 3 ways to protect intellectual property: action, contract, and registration. That is universal, except for the registration can't be done with a trade secret, because again, have to be secret. But in all situations, whether online or not, action, contract, and registration. So I'm actually going to start with registration just because it's quickest. Registering your intellectual property puts everybody on notice that it is yours, that it has been verified by a government body as fitting into that category of intellectual property. It allows you to use those special marks, the C with the circle, the R with the circle, rather than just the TM or the word trademark or the word copyright. It also allows you to get some of your statutory fees back if you have to go enforce your trademark and copyright. So those can be very helpful tools. Copyright, it's relatively cheap to do. It's about $55 per registration with the United States Copyright Office. Trademark's a little bit more expensive. It's $225 per class of goods and services per mark. So if you have the name Polaris Law Group and you're doing legal services, that's $225. If I also wanted to do my logo, that would be an additional $225. If I also wanted to branch into accounting, which I don't because I don't do accounting, but if I did, that would be an additional $225. So that's registration. Just puts people on notice, gives you a little bit of reassurance. Contracts can be trickier online because oftentimes if you're working one-on-one with somebody, so if you have your contractor, if you're a general contractor with subcontractors, or if you only do contract work with clients, you can have them sign a contract and you've worked out that contract together, easy peasy, you can protect your intellectual property within that contract. When you're online, it's often harder. And by harder, I just mean most people don't think about doing it. So for example, today, I didn't have you guys do this. It's not that important to me. I want you guys to have this information. I could have asked the SBDC to include in the registration a requirement that everybody who is attending this understands that all of the materials here are my copyrighted property, and that they agree that they are coming here for educational purposes. They agree that they are not allowed to provide the PowerPoints or any recording of this to any third parties, that they agree that they're not allowed to use this for their own monetary purposes, and that they're not allowed to do anything else that would infringe upon my rights here. I could totally do that. I didn't. I want this information to be out there. But let's say instead that I am, my sister is a personal fitness trainer, and that she is doing a one-on-one training with somebody via GoToWebinar, and that she is showing them her unique and personal process for that. Well, that video that they are doing is her copyrighted material, and that process is probably her trade secret. So she could have, when they sign up for that class, that person agree that they understand that everything in that video is her intellectual property. They agree not to share it. They agree not to bring it out elsewhere, etc. Similarly, in your terms and conditions on your website, you can have these intellectual property protections. And if you do that, you can have a statement of what your intellectual property is, and as a condition of use on your site, that they are agreeing not to use your intellectual property. It's not the strongest agreement when it's like that, because you're assuming that people are going to use it. You're not really getting their affirmative consent on it, but it's a heck of a lot stronger than nothing. We once had somebody who had taken a lot of pictures of their inventory and put it in their shop online, and somebody was ripping off the pictures from their shop. Well, they didn't have terms and conditions online, so we were going to have to enforce that in Canada, where the person was. Well, that's difficult and expensive. So if they had had those standard terms and conditions, we might have been able to include a choice of venue clause or liquidated damages, or even just a statement as to they had taken those pictures and therefore not have to have proven that they were theirs versus a third party. So that's where contract can protect you. And finally, actions. These are things such as putting marks, putting that your site is copyrighted, putting that your photos are copyrighted, putting that your videos are copyrighted. If you have things that you want only your paying clients to see, putting them behind pass walls, putting them behind logins. That's especially important if you're doing any sort of recorded videos. If you have stores, that could include watermarking your photos and keeping track on them, as well as doing these checks every once in a while and just making sure that you are keeping an eye on what of yours is out there in the world. That's how you protect your own websites, your own online materials for your intellectual property. But it's also important not to infringe somebody else's. And typically, we're going to go through this process to determine if you have infringed somebody else's works. If you've taken them and put them on your website, your first question is it yours? That's usually an easy one to answer if we're even in this category. But sometimes it isn't. If you've hired somebody to create videos for you, or if you've hired a photographer to take pictures, do you have that permission to use those in this way? Sometimes if you have signed a contract with a contractor, you've reserved certain rights to them, reserved certain rights to yourself. You need to make sure this is one of the rights that you have with those materials. So the next question is, did you get permission? So if it's not yours, did you receive permission for it? One of the easiest ways to do these is so we get this a lot of times with businesses who have taken pictures off of Google for their website. Not okay, you haven't gotten permission for those. However, if you're a member of something like Creative Commons, or if you're a member of one of the sites that allows you to pay a subscription and you get access to all of their images, that's permitted. The pictures that I used before in this are all part of my Microsoft Office license. So in that license, I have permission to use their stock photos for presentations. The next question is it in the public domain? So if you're going on Google, some of those might be in the public domain, but you need to be sure. So public domain are things that nobody is asserting their rights to them anymore. Either they have given them up or they have fallen into the public domain. So for example, if I were to get a picture of George Washington, that the famous picture of George Washington standing, that would be in the public domain at this point. If somebody has painted their own image of that, that might not be, but it can be in the public domain for that reason. I think Wikipedia Commons is largely public domain images. So that would be that next check. And then finally, is the use that you're doing it for fair use? Meaning, is there an exception to getting those permissions? However, if it's for your business website, I can almost guarantee you right now that the answer is no, it is not fair use. Even if you're a nonprofit, the odds are really good that if it is for your nonprofit website and it is designed to bring traffic in, it's probably not fair use. There are a couple of exceptions for that. If you're doing parodies, for example, that might be the case, but otherwise probably not. If you answered no to all of these questions, don't use it. However, I am about to give a caveat to that, given a question that came in before we started on this. If you are linking things to other websites, at that point, you're not infringing if you are literally just providing the link. You are referring. So for example, if I am writing a blog post and in that I have a list of other articles that may be interesting, or I'm not actually really talking about this issue, but I think that people who are reading it might be interested in seeing that, then I might link to those. If I refer to an organization, I link to that organization's webpage. Those are permissible because you're not taking somebody's intellectual property. However, providing a link is not an excuse for otherwise using somebody's intellectual property that you don't have permission to use. So if I take a picture of the maroon bells, this happens all the time, and I want to use that on my website because it's Colorado, awesome, and it's pretty, and I just put the link under it, and I say, well, that's sufficient, I'm giving them credit, you're still using that picture without permission. So how you link is important. If you are linking for reference, then that's fine. If you are linking because you're wholesale copying and you want to give credit to try and avoid the fact that you didn't get permission for it, not fine. So make sure that you keep this particular chain in mind with that. And then finally, takedown procedures with the intellectual property. If you are going to be hosting other people's intellectual property on your page, or if you're hosting your own intellectual property on your page, it's always good to have a takedown process in your terms and conditions. In your own intellectual property, it's more of a risk aversion thing. Hopefully you are just using your own intellectual property. But if you're allowing comment sections, you're allowing people to post things on yours, if you're hosting any sort of site where people can sell their own items on it, it's good to have takedown procedures. What the takedown procedures are is they allow for a creator of intellectual property to notify you as the business owner and the site host that you have their intellectual property on their page and ask you to take it down. These need to be responded to quickly. We always say you need to actually take it down within 48 hours of receiving the notice, and then investigate, and not the other way around. Investigating may be checking with your subcontractor, with your seller, and saying, hey, we got a notification of this. Can you give me proof that you got permission? Can you give me proof that this is yours? Doing that investigation. If you're satisfied, putting it back up, sending a notice to the person who asked to take it down, saying you completed an investigation, you've determined that this is your property or the property of the person who provided it to you, so that you're keeping it back up. If you're uncomfortable after that, keep it down. But you need to contact the person who gave you the takedown, let them know that you're conducting an investigation. You need to actually conduct the investigation. And only after you've conducted an investigation should you put the item back up. If it is a flat out, you took a photo and somebody is claiming that it's not your photo, I would still recommend taking it down, making sure that you uploaded the photo you thought you uploaded, and then confirming with them, I took this photo myself, it is from this date, I confirmed that I uploaded the correct photo here, it is the photo that is mine, done. It's just safer to go through the process than to immediately react. So those are your intellectual property considerations. Hannah, do we have any questions on those?
Yes, there was one that came in from Daniel. He's asking, what if you contract with someone to put things on your website? If you've paid for that content, can you use that?
Absolutely, great question. Typically, yes. Typically, that should be included in your contract, but you should always make sure that it is included in your contract, especially if you've contracted with someone to put things on your website, and if they are either a host or if they manage that website, you need to make sure that you retain the right to use those things if they no longer are working with you. That's usually where we see those issues, is if the relationship breaks down. So you need to just make sure that your contract with that person is clear. That should always be part of your contract. That's why you're paying for those services. You just need to double check it.
Great, thank you. That's our only question for this section. So we'll keep an eye out still for questions, anyone who wants to submit them for this upcoming section.
Great, thank you, Hannah. And I know we're getting close, but this is also a pretty short section. It's sales and solicitations. This is just basically talking about, and I keep it short because half of it will apply to those of you who are selling products and services, and half of it will apply to those of you with mailing lists. Some of that may apply to the same people, but I know that not everything in this section applies to everybody, so I'll keep it brief. Online stores, common concerns: that you're bringing in personally identifiable information, particularly credit cards. Sales tax. A common issue with this is that you are not either accounting for sales tax correctly and that you're going to owe a big chunk from a bunch of different states, or that it takes way too much time to account for sales tax. We highly recommend that you utilize a bookkeeper if you are using an online store. There are programs that will calculate out sales tax for you. There are also ways to ensure that either you're eating it on one end, you're giving a flat price, and you're just understanding that it's going to average out over time. But sales tax is not the same in every location. When you are selling online, you are worrying about the sales tax of where your buyer is, not where you are. And so one of the common mistakes that we see businesses starting out online is not taking that sales tax issue seriously enough. Again, if you are starting out, you can always limit where you will ship to. You just need to make sure that you include those limitations in there. A lot of people who are helping you design your website at the outset can help you with how to make sure that people aren't putting in a state that you're not willing to calculate sales tax for yet. So if you're saying we only want to do Colorado, Utah, Nebraska to start out with, you can make sure that those are the only 3 states available in that drop-down list. If you want it to be available to everybody, that's fine. I highly recommend getting a bookkeeper online for that. Another common concern are the shipping, refunds, and returns. You want to make sure you have those policies from the outset. You don't want to wait to have to enforce a policy that you never put on paper. Again, if you have store terms and conditions, if you have purchase policies, if you something like that that's online, usually we say separate from your privacy policies. If you possibly can, you want to know what those are. You want to be able to enforce those on your own. You also may need to coordinate with some third parties on that. If you're using credit card providers, third-party credit card providers, you need to see what their refund policies are before you apply your own refund policies. If you're using a shipping service that you're not willing to pay for 2-day shipping, you need to know what those policies are. If you're using a shipping service that is going to leave it at their door, you need to know what those policies are. So it's helpful to understand what the third-party rules are that you're working with. Product liability, obviously a concern for online stores depending on what products you are. Usually, again, you just want to be open and honest with your customers. What happens if something happens? What happens if something gives them an allergic reaction? Do you need to say that you haven't been FDA tested? Not everybody does. Do you need to say that you aren't responsible for product liability? That will happen if you are a retailer, but not the manufacturer. If that's the case, how do you set them up with product liability? If you're their point of contact, you need to make sure that you have a way to get them that communication if something happens, so that you don't end up in the middle of a nasty lawsuit. Best way to handle those kinds of things. Accidental exporting, this is also something obviously that I care about a lot, but that happens more often than you think, is if your product leaves the country due to a sale, you are responsible for exporting that, whether it was ultimately your issue or not. So for example, if somebody buys 20 of your product and sends it to Idaho, and then sends it from Idaho to Iran for sale, you have just exported your product. Now with some of those, if it's a personal use, that's a different story. If somebody ships one of your products to Idaho, and then that person who purchased the product brings it to Iran and then resells it in Iran, not your problem. It is your problem if it is reasonably an amount that would be for resale and not for personal use. So you were put on notice that somebody might be trying to resell it, or if you affirmatively ship. So again, if you don't put that limitation that continental 48 or even just outside of the US and Canada, if you're doing Canada, you need to do the appropriate paperwork, and somebody buys from the UK and you ship it to the UK, you have now exported without going through the proper Customs and Border Patrol. So it's important to either put those limitations on yourself or to speak to an attorney or a brokerage about that prior to doing those things. Good idea anyway, I didn't put this on here, but to be aware of when people are buying resale amounts of your products. Usually I recommend that if you have the ability to sell a lot of a single thing, that you put a note in your terms and conditions that over a certain amount they need to contact you directly. Sometimes it might be for events, it might be for something like that, but that way if somebody does want to resell your items, you can have different terms and conditions around that than your personal use purchasers. Newsletters and mailing lists obviously have slightly different concerns than online stores. Again, you want those opt-in, opt-out options. They need to do it. They need to do it easily. If there is a 6-step process to unsubscribe, you are probably violating privacy policy somewhere, as well as making somebody very, very annoying. It really needs to be button, maybe a survey, maybe. I'm not 100% offended if you do the survey afterwards to ask why they're opting out, but if that survey makes it more difficult to do so, then I would highly recommend against it. And the opt-out needs to be real. No, it takes them off for 3 months and then automatically puts them back on. If somebody is asking to be forgotten or to unsubscribe right after they purchased something, you can say, if you need that information in order to be able to fulfill their purchase, doing this will cancel the purchase. Can I do this after we've sent this all to you, et cetera, and so forth? That's perfectly fine. To the extent that you need to keep purchase orders, you can absolutely keep purchase orders, but you need to have rules and regulations internally governing your small business as to how long you keep them, why, where, how, and when you destroy them. So if you only need to keep them until the next tax season, then that means that on May 1st of every year, you have a shredding party of all of the purchase orders from the previous years. And if that's the case, again, that needs to be in those agreements, that needs to be in those disclosures, that you are keeping this information for your own tax and financial records for the following amount of time, and then this goes away. Need to make those disclosures with your newsletters and mailing lists about who gets the items, about how often they'll get the items, about if you have third-party links in the items, being careful using those. Please try to avoid giving advice online. I know that seems silly listening to a legal presentation. You go, Sam, but you're giving, no, not legal advice, educational information. If you need disclaimers for your particular industry, make sure you have them. Make sure you give them at the beginning and end of things. If you're an accountant doing newsletters, that should have a disclaimer. If you're doing advertising on things, make sure you read your advertising agreements, understand what information they will be taking. Are they going to be putting cookies on your site that you need to disclose? Are they going to be asking for your mailing list? Those are all important factors to protect yourself. And any questions on that section at 11:57?
We don't have any questions on that section. Oh, one just came in.
Awesome.
Daniel asks, if I do an online video about what I think on certain topics, do I need to do anything to protect me doing that video?
Perfect. So I'm guessing, assuming in the giving advice sort of option, if you're giving a video like that, it doesn't hurt to have a disclaimer at the beginning, to say something along the lines of, you know, well, okay, not knowing your industry, it's a little bit difficult, but let me give it an example. Fitness, to say, hey, you should always check with your doctor before doing any of these things. Don't do these if it hurts. I'm not there with you. I can't actually see that. If you're doing a hair dyeing video, it's good to say, hey, now don't use any products that, you know, I can't give you advice on which products to use. I don't know your allergies. I don't know your skin type. Use these things at your own risk. Something short and sweet like that, something like the slide that I had at the beginning of this, just to pull up at the outset. Or if it's a video, like a YouTube video, and you can put something in the description, also very helpful. But yes, I would highly recommend giving a disclaimer that is appropriate for your industry before videos.
Great, very helpful. Well, it looks like those are all of our questions. So thank you again, Samantha. This was really helpful information to make sure we are all using best practices for protecting our own businesses and when working with other businesses. So we hope everyone's questions were answered during the presentation. And if you have more one-off questions, you can reach out to Samantha. I think she might put up some.
Yep.
There we go. Yeah, contact information there. And as a reminder, at North Metro SBDC, we offer free business consulting available at northmetrosbdc.com. So for more in-depth questions, you can book a consulting appointment with Samantha or any of our other experts in the fields of marketing and financial, startups, human resources, and so forth. It really is a great resource, free of charge. So again, that's northmetrosbdc.com. And it looks like we may have time maybe just for one more question that came in from Cami. She asks, when registering a copyright for a website that includes a blog, are you required to register each post, or is registering the entire site once sufficient?
That is an excellent question. I'm glad you asked it. You have options with the Copyright Office of registering an individual item or a compilation. Typically, we presume that websites are going to be compilations because there's several different pages that are together. Blogs, similarly, sometimes we even do your blog site separate from your website because it's really those creative blog contents that you're looking at. So we do recommend doing that, partially also because there is an increased cost for doing a compilation for an individual, but when you add it all up, doing each individual blog post is far more expensive than doing a compilation. So if you have an active blog site, we would recommend that you split it into series for your registrations, that maybe you do it on an annual basis and you register everything from the previous year, or that if you're more active, even on a monthly or on a quarterly basis, to get both recent protection as well as bang for your buck on registering that. Great question.
Great. Yeah, thank you for answering that. And thank you everyone for taking the time to join us today. We hope you'll join us for other upcoming webinars, which you can register for on our website. Thank you, Samantha, for all the great information. And we hope everyone has a great afternoon.
Thank you, Hannah. Thank you, everybody listening. And what Hannah said about if you want consultations, talk to the North Metro SBDC and we'll get you set up.